So the main difference is that the process is all in the U.S. You do not have to go out to a consular interview. So normally if a U.S. citizen, a spouse, has been in the U.S. unlawfully present, the traditional way would be to file for a 601A waiver, and then at the very end of the process, go to the interview in the consulate where they are from. Now, the entire process is in the U.S. They do not have to separate from their families. They can get a green card through adjustment of status as opposed to the consular processing. With this new parole in place, you get the parole, and then immediately after, once it's approved, you can file for a work permit and then eventually for your green card. People can stay together with their families. Even going to an interview for the green card is not something where you need to go outside the country, but now you are here and you have peace of mind that everything is going to be when you have your spouse next to you. This specific policy was intended for the spouses of U.S. citizen and the stepchildren of U.S. citizen. They have to have been present in the U.S. for the past 10 years and then just demonstrate that you deserve the benefit, that you should be allowed to stay here, that you don't have any criminal record, that you don't have any issues with the law.
Something that comes to my mind is physical presence. I know you've dealt with that before with your I-485 cases. So what are some documents that you would usually recommend to submit for that?
I normally tell my clients to kind of think through their life and what type of special events were going on in their life for whatever the period of time we need to prove physical presence. For example, if you got married, if you had a child, if you got divorced, if you were working at a certain place, were you in a school, did you have a bank account, did you have any credit cards, any loans, did you purchase a property? So any document from a third-party entity that can prove there is a legitimate physical presence tied to that individual. We normally don't use affidavits. I know a lot of people are used to writing out letters. You know, I can get a letter from my brother, my sister, my mom, my dad, my neighbor. Those are okay to use when you don't have any third-party documents. I know it's kind of hard because in my experience, what I've seen for the last 12 years, clients are limited on what they can do in the U.S., right? You don't have a social security number, you cannot get a loan. You don't have a social, you can't get a bank account. So we have to strategize with each individual person so that we can give them advice. But generally speaking, it's just the school records, medical records, hospital records, and like I said, any special events that might have happened.
So let's say I put together my I-131F. What are the next steps? And then do you know anything about the current processing times?
So this policy is fairly new. They have not published the processing times as far as how long it's going to take for adjudication. Normally what happens just based on history is when there is a new policy that comes in place, USCIS is prompt in approving because they want to use that as an incentive for other applicants. Some applications were approved. They were filed on Monday when it became effective and they were approved on Tuesday, and they are valid for 2 years.
So Gabby, I know you've been really busy attending all sorts of info sessions through AILA and through USCIS, and I'm just curious to know, what have you learned from those?
It was very interesting to know what would happen if the applications are denied. Based on the seminar that I attended on Monday with USCIS, they said that cases are not going to be referred to ICE for proceedings or removal proceedings, meaning they won't come knocking on your door because it is a discretionary program. So they normally do not release the data to the other agencies unless they deem your case to be a potential risk to national security. And then also, what would happen if I already have a waiver case? If I have a 601A waiver and my case is in process, can I apply for this new parole in place program? The answer was yes, you can apply and you are actually eligible to continue with your adjustment. People are not restricted because they already have a pending case. And it was also good to know that they won't be referring any cases specifically for removals.
I know you mentioned like people are already trying to block it. Is that right?
Texas filed a lawsuit challenging the policy, and they basically want to do the same thing they did for DACA. I think what we need to do now is just be diligent. I remember when DACA was challenged, right? There is a process, there is things that need to happen before it's completely stopped. So I think we need to move quickly, and like I said, just try to help as many people as possible. Feel free to contact us if you have any questions.
Bye.